Welcome to this update on supplementary protection certificates. Your speakers today will be Chiska Boris, a partner in our Life Sciences Regulatory team, myself, Robert Burrows, a partner and joint head of our patent litigation team, and Katie Cambrook, who is an off-counsel, also in our patent litigation team. Between us, we will provide an update on some recent SPC cases of note, principally from the UK courts and the CJEU, and some upcoming legislative changes. Before that, though, it is worth reminding ourselves of the current SPC system and the basic conditions for grant. SPCs are national rights which can be used to extend the duration of a patent by up to 5 years, plus a further 6 months if a paediatric extension is also granted. The SPC system is designed to provide a degree of compensation for the delay it takes to bring a patented medicinal product to market. Once granted, and always within the limits of the relevant patent claims, an SPC extends the period of protection for the product covered by the associated MA until the date of SPC expiry. When I refer to the limit of the patent claims, I mean that if a claim is, for example, to a process or a dosage regimen for a particular product, the SPC will also be limited to the process or dosage regimen for that product. By and large, the system is fit for purpose and can be immensely valuable for patent holders, but there are a number of issues that remain unresolved and unclear despite, in some cases, repeated assessment by the courts. Two important developments that we will come back to later in this podcast are the Unitary SPC and the EU Commission proposals to reform the SPC regime. When it comes to obtaining an SPC for a product, we need to look at the conditions for grant in Article 3 of the SPC regulation. Regarding those conditions, and taking them slightly out of order from those on the slide, an SPC will be granted if, in the member state in question and at the date of the SPC application, the product is protected by a basic patent in force and has not already been the subject of an SPC, and that's Articles 3A and 3C. In addition, a valid MA must have been granted to place the product on the market, and that authorization is the first MA to place the product on the market as a medicinal product. That's Articles 3B and 3D. We also need to be aware of Article 1B, the definition of product, which means the active ingredient or combination of active ingredients of a medicinal product. Katie will now begin our review of some recent SPC cases.
Before we take a look into some of the cases in a little more detail, we thought it would be useful to set out a short timeline of recent cases. At the end of last year, listeners may recall the decision of Michael Tappan KC, sitting as a Deputy High Court Judge in the Merck Serono case. In this case, Merck was seeking an SPC for their medicinal product Mavenclad, which contains the active ingredient cladribine for relapsing and remitting multiple sclerosis. This active ingredient has been the subject of an MA before, in the 1990s and 2000s, for a use in hairy cell leukemia. As such, and following the CJEU's decision in Santen, the most recent marketing authorization was not the first authorization to place the product on the market, and the application for the SPC, as well as the appeal of the Patent Office's decision, was rejected by the judge. Merck have further appealed this decision, and it will be heard by the Court of Appeal in December 2024. In February this year, we had the Neuron case in the Court of Appeal. This related to whether Neuron could be awarded an SPC on the basis of a basic patent which covered a combination of safinamide, levodopa and PDI. The MA had been held in the lower courts not to be the same combination, but to safinamide alone. This meant that there was a mismatch between the basic patent and the marketing authorization, and following CJEU case law, the Patent Office and the High Court had therefore rejected the application. The same happened before the Court of Appeal. The remaining cases noted on the timeline, Halozyme, Teva and Merck, and Genmab, we will now cover in a little more detail. First up, we're going to look in a little more detail at a decision from the UK IPO. This decision relates to the company Halozyme, who had applied for 2 SPCs for 2 of their products. The SPCs related to trastuzumab plus recombinant hyaluronidase and rituximab and recombinant hyaluronidase. The SPC applications each listed their respective basic patents and the marketing authorizations upon which they relied to obtain the SPCs, as required by Article 3 of the SPC regulation. In relation to the MAs, those relied upon are line extensions to previous marketing authorizations for trastuzumab and rituximab, respectively. The issue in these proceedings was that Halozyme considered that the marketing authorizations it relied on were to a combination of active ingredients, but the Patent Office did not. The difference lied in the role of the recombinant hyaluronidase within the medicinal product, and whether or not that element constitutes an active ingredient under Article 1B of the SPC regulation. If it was considered as such, then the applications could proceed, and the marketing authorizations relied upon would be the first marketing authorizations to place that combination of active ingredients on the market. There are a number of relevant decisions concerning Article 1B which listeners may be familiar with. At the outset, I should say that Article 1B has been interpreted in previous cases quite strictly. From the case law, it is established that for a component of a medicine to be considered an active ingredient for the purposes of Article 1B, it must have an effect of its own on the body. It is not enough that it helps an active ingredient to do its own work. The key question, therefore, is whether the substance in question has a pharmacological, immunological, or metabolic action of its own, which is covered by the therapeutic indications of the marketing authorization relied on. The UK IPO in this case had to assess, therefore, the role of the hyaluronidase, and in doing so look at what documents should be relied upon to assess that role. In reviewing the application and considering the role of hyaluronidase, the Patent Office considered the marketing authorization-related documentation, namely the SMPC and the EPAR. These documents listed recombinant human hyaluronidase as an excipient. Its role is to increase the dispersion and absorption of trastuzumab or rituximab when administered subcutaneously. The applicant, however, argued that the recombinant hyaluronidase had an indirect and direct effect on the body, relevant to the particular treatments of cancer identified in the respective marketing authorizations. In support of this argument, they relied on some of the clinical studies referred to in the respective marketing authorizations, references to the basic patent, and also some other scientific publications which were cited in those patents. They considered that referring only to the marketing authorization documentation was too literal an approach and ignores the properties of hyaluronidase that means it can qualify as an active ingredient. The hearing officer, however, did consider these additional documents, but considered that his approach was the correct one, that being one which is SMPC or EPAR-led. The hearing officer said that that does not mean that any additional documents will be looked at in isolation, but they should therefore be looked at together with the SMPC. The hearing officer found support for this approach in his consideration of the role of hyaluronidase, including from the recent Neuron decision that we mentioned earlier. From the assessment, the Patent Office concluded that the recombinant hyaluronidase is not an active ingredient. It does not have the same pharmacological, immunological, or metabolic effect as the identified active ingredients in the SPC applications. While the additional documents relied on by the applicant were said to indicate that the hyaluronidase has properties that show its potential to be used to treat cancer, it does not provide information on how the hyaluronidase acts in the treatment of a specific cancer. Therefore, while the recombinant hyaluronidase has an effect on the body, its effect is not in, e.g., treating breast cancer, which is the use for which the trastuzumab product is approved. Given the active ingredients were each of trastuzumab and rituximab alone and not the combinations, the SPCs could not be granted. Further, in relation to the trastuzumab SPC, this was held not to comply with Article 3C, as an earlier supplementary protection certificate for trastuzumab alone had already been granted in the UK. Halozyme appealed this decision and it was heard in November 2024. We await judgment from the High Court. The Halozyme dispute was not isolated to the UK, and the UK IPO decision made reference to litigation around Europe, including in countries such as Spain, Portugal and Poland, where following appeals the SPCs had been granted, and France and Germany, where the SPCs had been refused, albeit at the time of the UK IPO decision that was subject to appeal in Germany. More recently, the SPC has been refused in Sweden. It is of note that both decisions in Sweden and France were by the Supreme Court in those countries, having found, in both instances, that the recombinant hyaluronidase was not an active ingredient. The Czech court appears to have recognised the diverging decisions across Europe, and in June 2024 made a reference to the CJU. The court has asked 6 questions, summarised on this slide. 4 of which refer to Article 1B considerations that we discussed above. It could take some time to get a decision from the CJU if it goes to a full hearing, Advocate General opinion, and then a decision. However, perhaps given the case law before this case and the strict interpretation of Article 1B and what is and is not an active ingredient, the CJU may decide this case by reasoned order.
Thanks, Katie. We are now going to look at a pair of cases concerning combination products, one from Finland, the other from Ireland, which have referred questions to the CJU on the interpretation of Articles 3A and 3C. In essence, the cases concern the extent to which an SPC may be granted for a combination of active ingredients in a product where a previous SPC has already been granted for one of those active ingredients. In simple terms, can you have an SPC for a combination of A and B when you have already had an SPC for product A alone? The first case involves Teva and Merck and concerns a challenge to the validity of Merck's SPC for a combination of sitagliptin and metformin. The claimed products were for use in the treatment of diabetes and, importantly, metformin was a known compound for treating that condition when the patent was filed. Looking at the claims of the patent, we see that Claim 1 was to a class of compounds defined by reference to a Marcouche formula. Subsidiary claims refer to specific compounds including sitagliptin, and Claims 20, 25 and 30 related to a combination of substances, with Claim 30 referring to a combination of a compound from Claim 1, so sitagliptin for example, and metformin. Merck obtained a first MA in Finland for sitagliptin as the sole active ingredient in March 2007, and an SPC for sitagliptin was granted based on that MA and the patent. This first SPC expired in September 2022. Merck also obtained a second MA in Finland, this time in March 2008 for the combination of sitagliptin and metformin. A second SPC, this time for the combination product, was obtained based on the second MA and the patent, which expired by the later date of April 2023. The second case involving Merck and Clonmel involves a very similar set of facts, albeit this time in the context of products used for lowering cholesterol. Again, the patent included claims to a specific compound, in this case ezetimibe. There were also dependent claims to combinations, in particular Claim 17, which was to the combination of ezetimibe with simvastatin, a known compound for lowering cholesterol. Looking at the SPCs, we have a first SPC for ezetimibe, based on the patent, and an MA for ezetimibe as a sole active ingredient. That SPC expired in April 2018. We also have another SPC, this time for a combination of ezetimibe and simvastatin, which expired a year later in April 2019. That SPC was also based on the patent, but a later MA filed in respect of the combination of ezetimibe and simvastatin. The question again was whether this later combination SPC was valid. In both cases, a series of questions referred to the CJEU on the correct interpretation of Articles 3A and 3C and the validity of those SPCs for the combination products. Questions under consideration included whether it is possible to have more than one SPC on the same patent, and if so, to what extent do concepts such as the core inventive advance of the basic patent have in the assessment. Whilst we don't yet have the final CJEU decision, we do have the non-binding opinion from Advocate General Emilio of Cyprus, which was handed down in June this year. The first parts of the AG's opinion concern the correct test for determining whether Article 3C has been met, i.e. how to determine whether the product has or has not already been the subject of a certificate. Many of the interveners in these cases thought that the answer to the question of whether these types of combination SPCs were valid, at least if you were looking to invalidate them, lay in Article 3C. But as we shall see, the AG was not persuaded. He proposed a very straightforward test for Article 3C. First, define the product for which the SPC has been applied for, or in these cases has been granted, and second, determine whether the patent holder has already obtained an SPC for the same product. Here, the A plus B combination, or sitagliptin and metformin, if we consider the facts of the Teva case, is the product under Article 1B. There had been no prior SPC for this combination. There was only an SPC for A alone, or only for sitagliptin. Moreover, that prior SPC for A alone should not preclude the grant of another SPC for the A plus B combination. The AG's views are therefore at odds with the reasoning set out in the Actavis cases from 2013 and 2015, which had similar fact patterns, but where the CJAU considered that Article 3C and the presence of an earlier SPC for A alone did preclude a second SPC for a combination of A plus B. In those earlier cases, the court considered that only A was protected by the patent. That was the core inventive advance, and A had already been the subject of an earlier SPC. In the Advocate General's opinion, those Actavis cases ignored the definition of product in Article 1b. They also conflated the condition set down in Article 3a, namely what is protected, with the requirements of Article 3c. In his opinion, whilst the conditions are cumulative, they must be assessed independently. As per the quote from the AG on the slide, however laudable their intention, the courts in the Actavis case overrode the clear wording of the SPC regulation. Turning to 3a, what does protected mean? The Advocate General references the Beetlestrack, the long and winding road, prior to embarking on his review of what he considers the meandering line of case law that has attempted to clarify the meaning of this condition. The starting point is Pharmatalia in 1999. Is the product covered by the claims construed according to national rules? Since Pharmatalia, and according to the AG, the court has given its own autonomous meaning to the term protected. This meaning is more stringent than it is when considering patents, such that a product could be protected under patent law, but not under SPC law. Looking at the cases which followed Pharmatalia, they either introduced an identification test or an invention test when considering Article 3a. We therefore have cases such as Mediva and Eli Lilly, which are identification cases, and suggest that the combination product must be expressly referred to in the claims, or at least be identifiable. In parallel, we have the Actavis cases, or invention cases, where a product is only protected if it represents the core inventive advance or is the sole subject matter of the invention. These cases led up to the well-known Teva versus Gilead case, which the AG refers to as the definitive case on Article 3a. This case established a two-pronged test. First, the combination must necessarily, in light of the description and drawings, fall under the invention covered by the patent. And secondly, each active ingredient must be specifically identifiable in the light of the information disclosed in the patent. This could be an express reference, but it doesn't have to be. Importantly though, you have to satisfy both limbs of the Teva test, the identification and invention limbs, in order to be protected. It is not enough for the actives to be mentioned in the claims or be identifiable. In this regard, the AG stresses that his opinion is not called into question by the later Royalty Pharma case, which did not concern a combination product and stated that the concept of the core inventive advance was not relevant in the context of Article 3a. To summarise, looking at the facts of these pending cases, and assuming the Advocate General is correct, the combination products would satisfy Article 3c, but would not appear to satisfy Article 3a. The products would not be protected, as they do not fall under what the AG considers to be the invention covered by the patent. In both cases, the invention is said to be about A alone, or the class of compounds to which A belongs. It is not about the combinations included in the later claims. It remains to be seen, though, whether the AG's opinion will be followed. The panel of judges who will decide these references have plenty of SPC experience between them, and a number of them are involved in the Teva, Royalty Pharma and Actavis cases considered by the Advocate General. Their decision is therefore awaited with great interest. The direction of travel, though, from the cases to date is that combination SPCs of the type considered in these pending references are not looked upon positively and will fail either because they do not satisfy Article 3a, as per the AG's opinion, or because they do not satisfy 3c for the reasons set out in the earlier Actavis cases. Katie will now cover another recent case.
Genmab had a marketing authorization for ofatumumab for the treatment of relapsing and remitting multiple sclerosis. However, the same active ingredient had been the subject of a previous marketing authorization for untreated chronic myeloid leukemia, or CML for short. The previous marketing authorization for CML had been withdrawn at the time that Genmab had applied for an SPC on the basis of the newer marketing authorization for relapsing and remitting multiple sclerosis. The Hungarian court in this case asked the CJEU whether it made a difference that at the date of the application for the SPC based on the relapsing and remitting multiple sclerosis marketing authorization, the older marketing authorization had been withdrawn. The question arose as the previous cases of Santen and Abraxis, which looked at a situation where an earlier MA was still valid, didn't consider where the MA had been withdrawn. Genmab also pointed to the English wording of Article 3D of the SPC regulation, which states at the date of the application is important. If considering this, then at the time Genmab applied for the SPC for the relapsing and remitting multiple sclerosis, then only one valid marketing authorization was in place under Article 3B. The CJEU answered the question from the Hungarian court in a reasoned order, stating that it is of no consequence whether the old marketing authorization was still in existence or had been withdrawn. This is in line with the strict interpretation of Article 3D. Over to Chiska.
Thanks, Katie. Let's now turn to the legislative proposals to amend the current SPC regime in the EU. There are 4 pieces of legislation related to SPCs, 2 for medicinal products and 2 for plant protection products, which are making their way through the EU legislative train and the EU institutions. In relation to the 2 legislative proposals related to medicines, in April of 2023, the European Commission issued its proposals for the SPC regulation recast and the unitary SPC regulation. In relation to the first proposal, the SPC regulation recast, it is to simplify the EU's SPC system as regards national SPCs for medicines, as well as improve its transparency and efficacy. Indeed, today's purely national procedures for granting SPCs involve separate examination proceedings which happen in parallel or subsequently in member states. This entails duplication of work, resulting in high costs and even discrepancies between member states in decisions to grant or refuse SPCs, including in litigation before national courts. Inconsistency between member states in decisions to grant or refuse SPCs is often referred to by national courts for primary references to the Court of Justice of the European Union on the application of the EU's SPC regime, for lead to significant legal uncertainty. The second proposal on the unitary SPC regulation is the natural next step further to the introduction of the unitary patent. As our listeners will know, the unitary patent entered into force on the 1st of June of 2023, allowing for a single patent that covers all participating member states in a unitary manner. Currently, a unitary patent can be extended by national SPCs, but of course this approach is not optimal because the unitary protection conferred by the unitary patent is, after the expiry of that patent, complemented by a number of independent national SPCs, losing that unitary dimension. The proposed reforms establish a centralized procedure for granting SPCs for medicines and a new unitary SPC based upon unitary patents. The centralized procedure for SPC applications would be available for both the centralized SPC applications and the unitary SPC applications. The idea is for the examination to be conducted by a centralized authority, but the actual grant of the SPCs would be done by the respective national offices of the designated member states, based on a positive opinion from that central examination authority. The opinion of the Central Examination Authority would be building upon the national offices of the designated member states. As far as the proposed unitary SPC is concerned, the proposal is that the application would be based on a unitary patent, that is, a European patent with unitary effect, and a centrally authorized marketing authorization. In this respect, most medicines are authorized under that centralized procedure anyway, and a unitary SPC application based on a national marketing authorization would have significant drawbacks. These would include a bigger examination workload, potential differences between the various national marketing authorizations granted for the products in certain different member states, including language issues. Some provisions in the Commission's proposal that are also worth highlighting and that you can see on this slide are: the effect of the unitary SPC would be the same as a national SPC in all member states where the unitary pattern has effect. In addition, an applicant would be able to submit a single combined application for unitary SPC in contracting member states and national SPCs in other member states. Thirdly, as mentioned already, the process for obtaining a unitary SPC is basically the same as for a centralized SPC application. Manufacturing waiver exemptions would be applicable to unitary SPCs. Finally, unitary SPC applicants or holders should be able to apply before the Central Examination Authority for extensions of unitary SPCs if a pediatric reward under the pediatric regulation is due, assuming the conditions in said regulation are met. This would require changes to the pediatric regulation, which the unitary SPC regulation proposes to make. This slide provides a graphic representation of the proposed centralized procedure. Interestingly, the EU IPO has been proposed to become the Central Examination Authority for granting national SPCs in member states and the unitary SPC. This has surprised some for the lack of expertise of the EU IPO, but the proposal is for the EU IPO to be supported by the expertise available in national offices. As you can see, the proposed procedure is complex and we don't have time to cover it in detail, but it is worth drawing our listeners' attention to the introduction of the possibility of having an opposition. This, coupled with the possibility of having an appeal to the Board of Appeal and even a further appeal to the court in Luxembourg, would make the whole process a lot longer than the current one. Founded concerns have been raised about this because of the possibility of having uncertainty around the granting of the SPC at the time of the expiry of the term of the patent. To minimize this possibility, the European Parliament has introduced the possibilities to submit a request for an expedited procedure in some situations and has added some timelines for some of the steps within the procedure. In fact, the European Parliament's proposals are in lilac on this slide. In this slide, we can see where we are with the legislative proposal package. After the Commission's proposal and their adoption by the European Parliament earlier this year, we are currently awaiting the European Council's first reading. It is possible that the legislation will be adopted in 2025, so watch this space for updates from us on this topic. I am now going to hand it over to Katie again.
We now propose to spend a few moments looking ahead to see what is to come for SPCs. As you'll see from the slide, the first point covers those actions in the UK. The first appeal we discussed earlier in relation to Merck Serono is due to be heard in December 2024, and the Halozyme appeal from the UK IPO's decision was heard in November 2024. We look forward to receiving the judgments in both those cases in early 2025.
We should also receive some further guidance by way of the decisions in the CGAU cases mentioned earlier in this podcast. We will therefore receive decisions hopefully this year, but more likely in 2025, from the combination cases and also the Halozyme referral. Another topic that we haven't covered on this podcast, but for which we should receive some clarity, concerns SPC manufacturing waivers. So far, we have had conflicting decisions from the Dutch and German courts on this area of SPCs, but we understand that the Dutch case on SPC manufacturing waivers has been appealed and should be decided soon.
We have already discussed the legislative changes at EU level, but what about the UK? We are not aware of any changes on the horizon, except for the changes that have already been laid before Parliament that will apply as from the 1st of January of 2025, that the implementation of the Windsor Framework will bring about for SPCs in the UK. With centrally authorised marketing authorisations no longer being valid in Northern Ireland as from the 1st of January of next year, and without the possibility of applying for Great Britain marketing authorisations from that date, going forward, this will eliminate the possibility of having two marketing authorisations to take into account for the purpose of obtaining an SPC in the whole of the UK going forward. This brings us to the end of this session. Thank you very much to our listeners, and goodbye.